Reverend Father Levon Kirazian, dear fellow parishioners and guests. On behalf of the Educational Committee, greetings and a warm welcome to each of you. We are indeed proud and honored to have amongst us the distinguished lawyer and guest speaker, Professor Michael Bazyler, who will speak to us on the subject of Armenian Genocide from Recognition to Reparation and International Court of Justice. Professor Bazyler will focus on how international law and tribunals have dealt with the legacy of the Armenian Genocide. He will furthermore examine the prospects of using Armenian litigation as a means of obtaining justice for heirs of the Armenian Genocide. Today's presentation is graciously sponsored by Ms. Azli Brunsuzyan. Professor Bazyler is a professor of law at Chapman University. He holds a Juris Doctor degree from USC Law School and a BA from UCLA. Before joining the faculty of Chapman in 2008, he was a professor of law and the 1939 Club Law Scholar in Holocaust and Human Rights Studies at Whittier Law School. Throughout his 25-year law teaching career, Professor Bazyler has been a visiting professor at various law schools within the United States, Australia, Russia, Belarus, and Israel, teaching different aspects of comparative law, public international and human rights law, international business litigation and transactions, criminal law, torts, and a course he created entitled Holocaust, Genocide, and the Law. In spring of 2007, he held the position of Distinguished Visiting Professor of Law at Pepperdine University, teaching comparative law and Holocaust, Genocide, and the Law. Professor Bazyler is the leading authority on the use of American and European courts to redress genocide and other historical wrongs. He has authored several scholarly publications, including the book entitled Holocaust Justice, The Battle for Restitution in America's Courts, which has been cited by the U.S. Supreme Court. The professor has testified in Congress before the House Reform Committee on the subject of Holocaust restitution and has been interviewed by CNN, 60 Minutes, Dateline NBC, ABC, NBC, NPR, BBC, and various other news programs. Without further delay, let us all welcome today's guest speaker, Professor Michael Bazyler.
Thank you so much for a very nice introduction. I'm really glad to be here. It's always my pleasure to come to the prelacy. I've been here a number of times and always have been greeted very warmly, and always has been a wonderful experience. It's so great to see so many of my friends here in the audience. Thank you for coming. Bahi, thank you so much for arranging for me to be here this afternoon. Since I'm a law professor, I'm used to asking my students questions, so I'm going to ask you a question first. Do you know what the connection is between the Armenian Genocide in Wales, not the country, but the animal? You know what a whale is, right? Yeah. Let me go ahead and tell you the connection that I see. And I never thought I'd be discussing the Armenian Genocide in Wales at the same time. International law is based upon rules that have been agreed upon by various nations in treaties. International law is also based upon customs that nations have agreed to over time. A treaty is like a contract. It's just the agreement is not between private parties, but is between nations. Now, if a nation violates the contract, if a person violates a contract or a company, what do? You go to court and you sue, correct? If a nation violates a treaty, an agreement, what do? You sue. So what is the forum that you would go in order to file such a lawsuit? And there is such a forum. It's commonly known, it's not the official name, it's known as the World Court. The official name is the International Court of Justice. In order to understand how this World Court came into being, we have to go back actually to the time of the Armenian Genocide or the post-Armenian Genocide in World War I, where at the end of the defeat of Imperial Germany and Ottoman Turkey, the various nations of the world established the League of Nations, which was a forum where instead of fighting war, nations would come together and would debate, and they would decide disputes diplomatically. If they are unable to go ahead and resolve disputes diplomatically, a court was established, which is the first world court, called the Permanent Court of International Justice. Sometimes is referred to by the abbreviations PCIJ. So that was the normative body, the judicial arm of the League of Nations. If you know about the history of international law, the League of Nations was not a successful organization. It did not prevent from having another world war. In fact, we had a greater world war, which is World War II. And so when Nazi Germany and Imperial Japan was defeated, the international community got together and said, okay, let's try it again. Okay? So the successor to the League of Nations was the United Nations, which is still in existence today. And one of the things that they did with regard to the organization of the United Nations, as opposed to the League of Nations, is they also created a body called the Security Council, where you would have the strongest nations in the world would come together, and they would have the power to actually send troops to various parts of the world in order to prevent aggression, in order to prevent humanitarian disasters. This is all the stuff we're reading in the news. It has to come through a resolution of the Security Council. The judicial arm of the United Nations and the successor to the Permanent Court of International Justice is this court called the ICJ, the International Court of Justice, which has been referred to not officially as the World Court. Okay? Nations can come and sue each other, and they can get judgments by judges that sit on the court. The court sits in The Hague, in the Netherlands, and they issue judgments. And on April 2nd, so today is what, April 6th, 4 days ago, there was a decision that was issued by the World Court against Japan, saying that Japan was violating international law. The lawsuit against Japan was brought by Australia, and it had to do with the practice of Japan allowing its fishermen to go and hunt whales. There are various treaties, agreements that nations have signed that limit the hunting of whales, but the Japanese, feeling because of their traditional way of life, they were given an exemption for what was called scientific whaling. And the International Court of Justice, these judges decided that Japan was abusing that exception for scientific, the fact that we're not doing it, and they ordered Japan to halt the whaling, the scientific whaling program that they're going to be doing. And the response of Japan is that they will abide by the judgment, that they will actually do so. This is for us who are, teach international law and try to promote international law as opposed to war, it is a wonderful decision because it shows that when an international court, the World Court, issues a decision, then a nation against whom the decision will be issued will agree to follow the decision. Now, technically, there is it's possible to take a judgment of the International Court of Justice that a nation has not been following and turn it over to the Security Council, and they can go ahead and issue a resolution even up to agreeing to send an international force into the country that's failing to agree to the decision of the International Court of Justice. That has never happened, and it's unlikely that is going to happen. The force that is going to make nations agree to international law is the moral force, and the feeling that if they do agree to it, then there's a benefit to them. Okay? So the International Court of Justice is a possible forum in order to see, and I'm doing this like as a law professor, kind of going through step by step, to go ahead and say, is it possible that a lawsuit could be brought to the successor of the Ottoman Empire, the current Republic of Turkey, to one, recognize the Armenian Genocide, two, for reparations. Nations can ask for reparations against another nation when they've been damaged. Okay? So you see that there is a forum that's possible. The details are the ones that give us, provide us trouble, provide us with obstacles that make it seem not very likely that this would be successful. Now, in law, we talk about precedent, other cases. So this case of Australia against Japan is one type of precedent. But there actually have been lawsuits that were filed for genocide, for commission of genocide, in the International Court of Justice. And in fact, there's one lawsuit that is going on at the present time. The first time that was done was 7 years, actually it was about more than 10 years ago, but the decision was issued 7 years ago in 2007. And I'm going to read you from the New York Times. I'm not going to read you the entire article, but this is the story from the New York Times talking about this. And the date line is The Hague, and it says as follows. The International Court of Justice on Monday, for the first time, called the massacre of Bosnian Muslims in Srebrenica in 1995 an act of genocide. So this is a lawsuit that was filed by Bosnia against Serbia for the genocide committed, in Bosnia during the time after the breakup of Yugoslavia. But the International Court of Justice determined, even though they said there was a genocide committed in one particular place at one particular time in Srebrenica, that Serbia itself was not guilty of the enormous crime. Obviously, the victims of the genocide were extremely upset with this decision, just as you can rightly be upset about the decision of the European Court of Human Rights, recently stating that the law that Switzerland had with regard to genocide denial also is somehow violating the Imperial Convention. So that doesn't mean that when you file a lawsuit that you will win. And you will see that, as you see that in this particular case, when Bosnia filed the lawsuit, they won, but they also lost. Because the International Court of Justice judges looking at it said, we don't have enough evidence, and they're looking at their particular case, to tie Serbia, and the Serbian military and the Serbian political authorities to the genocide that was committed in Bosnia. And then I'll continue with the article. Nonetheless, it linked Serbia to the genocide by saying that Belgrade could and should have prevented it, and in its aftermath should have punished the Bosnian Serbs, who systematically executed nearly 8,000 men in July 1995. Okay? This ruling was the first case in which one country had sued another for genocide. Okay? So that was the result of that particular lawsuit. Last year, another lawsuit was filed, also against Serbia, and this is another one of the successor nations after the breakup of Yugoslavia, and that's Croatia. So Croatia sued Serbia for genocide, and Serbia said, you sue us, we sue you back. We're going to sue you now for genocide. So, I'm going to read from this article. Croatia has sued Serbia for genocide, and this is from just last week's story, during the Balkan War, and Serbia reacted with a countersuit. Legal experts see little chance of success for either side in hearings starting Monday, and this is coming up tomorrow, in The Hague. Croatia had filed a suit in 1999 against the then Yugoslavia for genocide at the International Court of Justice. Some 15 years later, the hearings against Serbia, you see these things take a long time, okay, are set to begin. So see, 15 years later, they're going to actually start the hearings. The Croatians aim to prove that units commanded by Yugoslavia committed genocide in the war between 1991 and 1995. And more than 10,000 Croatians were killed in the course of this ethnic cleansing that went on in the former Yugoslav territory. The suit asks for Serbia to have all Serbian war criminals put on trial and all cultural assets seized during the war to be given back to Croatia, and calls for the payment of reparations to Croatia. Additionally, Croatia wants an explanation of what happened to the more than 1,400 Croatians who have been missing since the war. In 2010, Serbia filed a genocide suit because of the murder of more than 6,000 Croatian Serbs and the expulsion of more than 200,000 Croatian Serbs by Croatia during the Civil War. And in recent years, Serbia has offered to withdraw its legal action if Croatia will withdraw its legal action. Okay? So there will be hearings on this, as I said, beginning Monday. That's the possibility. Bringing the matter before the International Court of Justice, having some kind of a ruling from the ICJ, and I think having greater recognition. If a case is heard by the World Court, I think it provides greater recognition of the issue and any kind of statement that would be made by the International Court of Justice saying that what happened in Ottoman Turkey between 1915 and 1923 was a genocide, as you can see, would be a very important statement, because it's a statement that will be made by judges that are pronouncing on international law. Now let's go through the dynamics of how this could be done and where I see the problems there are. So who would be the plaintiff that would file the lawsuit? First of all, none of you can do it. Okay? The church can't do it. Okay? The only parties that can appear before the International Court of Justice are nations. Okay? So we say, okay, let's start a campaign to have the Republic of Armenia file a suit in the World Court against the Republic of Turkey. Okay? Both are members of the ICJ, and they can begin those hearings, and hopefully those hearings will not take 15 years. Right? There's the political consideration. Will Armenia, as a nation, will they want to go ahead and file the lawsuit? If they did file a lawsuit, and Turkey would hire me as their defense attorney, first of all, I would never take the case. But let's assume they would. Or there'd always be a law professor that would say, fine, I'm more than happy to defend you. Even if I disagree, everybody deserves a defense. I'm going to come and make the argument. So I'm putting myself in the head of this defense attorney for the Republic of Turkey. The argument I would make is this. Republic of Armenia. At the time these acts occurred, you did not exist. Right? How can you sue if you did not exist? It would be the same, I'm going to make the analogy, if today the state of Israel sued Germany for the murder of the Jews in Europe during World War II. Germany would come in and would say, Israel, you didn't exist at the time, and therefore you don't have the standing, I'm using a legal terminology, to go ahead and do so. I don't know how that would be resolved. I can only see that there would be a good, credible argument that Turkey would make. There is some precedent. It's not at the international level. It's at the national level, but it's been recognized internationally as international custom that a nation can take actions for genocide that has been done against it before it came into being. And the precedent for that is the Eichmann trial that took place in Israel in 1961 and 1962. If some of you may know, in 1961, Israel sent its agents to Argentina to capture Adolf Eichmann. And they brought him, kidnapped him, brought him to Israel in order to stand trial. And they allowed Adolf Eichmann to hire an attorney. They paid for that attorney. And Mr. Salvatius came from Germany to defend Mr. Eichmann in an Israeli court. And the argument, he actually made two procedural arguments. The first argument he made, and this is not related to this, but I think it's very interesting. The first argument he made for the dismissal is he said, you must dismiss this lawsuit because you are Jewish judges and you cannot, because of your prejudice, decide this case against the individual. And the three Israeli judges who were trying the case considered the motion, came back the next day and said, no, we will still consider it. We will put aside our feelings. We have to as judges. That's the role, the job the judges have to do. And we will look at the evidence, okay, to see whether we can connect this particular individual, okay, to these particular acts that occurred in Europe for the murder of the Jews. The law that was used to prosecute Eichmann was an Israeli law that Israel passed, which was based upon the Genocide Convention, but it limited strictly to the genocide of the Jewish people. And the law still is in Israeli books. It's called Crimes Against the Jewish People. And the Israeli court found Adolf Eichmann to be guilty of the crime of, the crimes against the Jewish people, committed prior to the state of Israel existing. That decision was appealed all the way to the Israeli Supreme Court, which upheld that decision. And Mr. Eichmann was, again, this was not guilty. He was given the death penalty, and Israel ended up carrying out the death penalty. That decision, the state of Israel versus Eichmann, has entered international law, okay, as a proper decision under international law. But you can see the differences. Here we're talking about a lawsuit against, not a lawsuit, but a criminal action against an individual, not a nation, before a national court. Now, I wish we could say today that we could find some perpetrator of the Armenian Genocide that we could bring before the court. And as you know, and this goes, we're talking about Sunday, we're on church property, so I'm going to bring in the biblical, statement that the sons are not guilty for the sins of their fathers. Okay, so the sons and daughters of the perpetrators or the grandchildren could not be put on trial today for the acts that were committed, by their grandparents. Okay, if you find a descendant of Tatalat Pasha, that person is not put on trial. You understand? Okay? But the precedent is there, and there's creativity that is going to be done. So that's the argument of the judges can decide, even if they're, have some stake in the outcome, they put that aside. And the second argument that the attorney for Eichmann made is that you did not exist at the time. And the decision that the Israeli judges issued, that the Supreme Court of Israel upheld, is that we, as the state of Israel, represent the Jewish people worldwide. And the Holocaust, the crimes against the European Jews, not all Jews in the world, but the European Jews, okay, impacted every Jew in the world. And so it's possible for the state of Israel, again I'm going to use biblical terminology, to have standing to prosecute that individual. So I think that would be precedent that if I was arguing, I would switch the other side for the Republic of Armenia. And if they hire me, I will take that case. I will represent them. I would make the argument that here we have precedent in international law that the Republic of Armenia does have standing to file a lawsuit in the World Court against the Republic of Turkey, which is the legal successor to the Ottoman Empire. Okay? So the possibility is there. There are political considerations, as I mentioned to you, right? And we don't know what the judges will do with that. Once the lawsuit, such a lawsuit will be filed, we know that it would be a very prolonged proceedings because they take a very long time. But it's something that has not been tried. Okay? I'm not a politician. I'm just a law professor in the ivory tower. Okay? So I can dream of things that politicians, can say, well, we have to be more practical. Whether it's possible or not, we don't know. But as you probably know, that things are moving ahead. New things are happening. Success is made. Scientific discoveries are done by who? By dreamers, right? So we have to dream that something that would be possible, and it's something that could occur. This decision by the World Court against Japan and the ongoing litigation by Croatia against Serbia and the countersuit at least provide us a template, a way of saying this is also possible. Okay? So now I'm speaking about international law and some kind of an action before a world court, an international body. As you can see, just like when Croatia is suing, and that's why I read this part of the article, Croatia is suing Serbia, what do you ask for in a lawsuit? You ask for reparations, which are damages that were done. You ask for the return and the restoration of the cultural property. If I was representing the Republic of Armenia, I say, what about all those churches? Okay? What about all that stuff that was stolen that we can somehow trace to now being in the hands not of individuals, but the state of Turkey, the Republic of Turkey. So those would be kind of the details that we'll be looking at. But damages can be filed, and the idea that one nation can demand reparations from another nation is an idea that has long been recognized in international law. Now, usually the way reparations are given is by a losing power in a war, not willingly, right, to the winning power. That was done after World War I, where the France and United Kingdom and Britain forced Germany to pay heavy reparations to the various nations in Europe that were damaged, suffered greatly as a result of Imperial Germany's attack. After World War II, again for political considerations, and this is something that was debated, the victorious Allies did not want to impose onerous reparations on both West Germany and East Germany. The Soviet Union was calling the shots in the East, and the Allies were calling the shots in the West. Right? But Germany, to its credit, and this is West Germany, right, willingly said, in order for us to join the community of nations, right, we will recognize that what we did, and we're not the Nazi state, but we are the legal successor to the Third Reich. We will recognize that what we did was wrong, and we will pay reparations. To whom? We will first pay reparations to Israel, right, as the state of the Jewish people, and we will pay reparations to the survivors from that genocide. Right? Israel and Germany met in representatives of Israel and Germany met in 1951 in Luxembourg, and they made an agreement where Germany, West Germany, paid millions of dollars to Israel. This was a very controversial decision in Israel, and there were many protests against it, against the Israeli government, because people were saying, this is blood money. Right? How can you accept that? It demeans the memory of the 6 million Jews that were killed. But Prime Minister Ben-Gurion, the first Prime Minister of Israel, was very pragmatic. They needed the money. They needed to build up their country. And they needed to take care of the Holocaust survivors that came to Israel after the war to seek refuge. So the Luxembourg Agreement came into being, and Germany paid that money. Nothing prevents the Republic of Turkey entering into a similar agreement with the Republic of Armenia. Right? And the various German chancellors, including the current Chancellor Angela Merkel, has told Turkey and Turkish individuals many, many times, look at our history. We are a better nation as a result of recognizing our duty past. Right? It has made us a better country. Right? Nothing horrible will happen to you if you recognize what happened in the Ottoman years to the Armenians and to the other victims. We can include the Greeks and other minorities, and to say this was a genocide. Okay? Because Germany did that. So we can dream about that too. That it's possible over time, maybe not in our lifetime, maybe in my children's lifetimes, maybe in the children's grandchildren's lifetime, something can happen, and something like that can occur. Okay? Now, is it also possible for Turkey at the same time to now pay to individual survivors? Well, there are no survivors of the Armenian Genocide, right? But the survivors of the Holocaust have been getting money from Germany on a monthly basis until they die. That money doesn't come to their children. Okay? So my father was getting money from Germany because he escaped Nazi Germany. His parents, my grandparents, my father's side were murdered. And he was getting a small pension every month from Germany. Once he died, the pension doesn't come to me. Okay? But for many Holocaust survivors, when they were getting that check, it was not the money the most important thing. What was really important is the recognition. Now, in the 1990s, and this is something that I have to tell you, and I'll speak for about 5 more minutes and I'll stop. In the 1990s, actually, professors, when they say 5 minutes, they never mean it. Lawyers never say that. So it's the lawyers and professors 5 minutes. Okay? So when, in the 1990s, claims started to be made against Germany. For the first time, in the 1990s, World War II had ended, so many years before, for German companies using Holocaust survivors as slaves, right? And Germany and German industry agreed in 1999 to establish a fund. The fund was $5 billion US dollars. And the fund was not just to Jews. In fact, the primary beneficiaries of that money were non-Jews from the Eastern European Slavic countries that were dragooned into the German economy to work as slaves, what they call them as forced laborers. And they ended up getting some money, from that. And the amounts were small. If you were a Jew and you survived Auschwitz, you would get $5,000. Imagine, okay? This is what you get. If you are non-Jew and you work as a farmer in Germany, you would get $2,500. But with every single check, okay, and when I say this, I mean, I've moved emotionally by this, okay? With every single check came a letter from the president of Germany apologizing to that survivor for the acts that were done. And those letters, okay, was more important than that, much more important than that check of $2,500 or $5,000. Okay? If you go to Berlin, there is the monument to the destruction of the Jewish people. Okay? We can all dream that someday, in Istanbul or Ankara, there will be a similar monument to the destruction of the Armenian people during the Armenian Genocide. It is possible for Turkey to do that. And paraphrasing now the words of Angela Merkel, Turkey will be a better country if it recognizes this, and if it says, yes, what we did was wrong, and symbolically, I wish, would have such a monument, in its capital or in its larger city. Okay? Now, I come from the point of view of a law professor and also as a litigator, as a lawyer. So now the question comes, well, until they do that, what else can we do? Okay? Since we're Americans, and especially American lawyers, what do? We sue. Okay? And where do we sue? We sue in American courts. Okay? So my entry into the Armenian community, many, many years ago, I went to Yerevan. I always have friends as Armenians. I always got the best Armenian hospitality whenever I came into the Armenian household. There will always be a bottle of the Mount Ararat over there. So I have fond memories of that. But in the 1990s, when I started writing about the Holocaust restitution, okay, I was contacted by someone who I admire very much, who's one of my heroes, who's sitting here, Bart Kasagayan. Says, I am filing a lawsuit against insurance companies for their profiting from the Armenian Genocide. And my feeling, initial feeling as a lawyer is like, this is impossible. Nothing is going to happen. And I read about it in an article, in the Los Angeles Times. And there was a quote in that article by Marcus that he talked about from lamentation and liturgy to litigation. That instead of April 24th, in addition to April 24th, coming together and commemorating it, okay, let's go from lamentation and liturgy to litigation. I like all the L's that are there. Okay? So I had an opportunity 3 years ago to publish an article on the use of American courts for the litigation for damages, not just against the Republic of Turkey, but any entity that profited from the Armenian Genocide. And I use the title from Varkas' statement in the LA Times, From Lamentation and Liturgy to Litigation. And when we write articles, we have to put always a colon and then something explaining what that means, right? So what the explanation is, the Holocaust-era restitution movement as a model for bringing Armenian Genocide-era restitution suits in American courts. Okay? I'm not going to take the time to go through all the possibilities that I see. I brought some copies of this. You're welcome to take it. If you run out, I have some more in the car. I didn't know what was going to be the size of the audience or the demand for this. Okay? So it's here for you if you want to pick it up. I also have some articles about Japan and the whales, so you can pick up a copy if you want to read more about that. And I can tell you, and I'll end this way, that there is litigation going on today in American courts, civil lawsuits, for damages arising out of the Armenian Genocide, both against the Republic of Turkey and also private entities. Whether they will be successful or not, I don't know. I am of counsel in some of those lawsuits, so obviously I have a particular point of view, and I have to be successful. And we'll see. Whenever I give a presentation, and I've done this before for Armenian audiences, I always bring up a name of another hero of mine. And his name is Benjamin Ferencz, F-E-R-E-N-C-Z. And I always tell Ben I do this. Ben is 94 years old. He is the last living prosecutor from the Nuremberg trials. And you can go and look at his website. And his website says, "Law, not war." At age 27, Ben, who was a young graduate from Harvard Law School, was just discharged as an Army sergeant, was made a chief prosecutor in one of the Nuremberg trials. There were a total of 13 trials. There was a main trial, and there were some follow-up ones. And since that time, he's been devoting his life to using international law to obtain some measure of justice for victims and for recognition of wrongs under international law. And his motto, and this is the motto I bring to you, something that I work on, is never give up. Never give up, and always dream. So I leave you with those words. Thank you.